Hi, my name is Chris Nolan. I'm a barrister at Queen Victoria Chambers in Sydney, and this video is about the standard non-parole period regime here in New South Wales. Criminal legislation creates criminal offences and states a maximum penalty for those offences. However, in general, it does not state a minimum penalty. And that means that judges have enormous judicial discretion when passing sentence to sentence an offender to anything from nothing at all to the stated maximum in the legislation. Now, this maximum sentence is reserved for the worst offenders, the worst possible objective facts, and the worst possible subjective features of the offender. And so no one ever gets the maximum penalty. Instead, almost everybody receives a penalty at the low end of the scale. And this has upset many people in the media who like to mislead the public and suggest that penalties are too lenient. So at every state election, both sides of politics compete to be seen as being the toughest on crime. And back in the 1990s, this led the Conservatives to propose removing judicial discretion and imposing mandatory minimum terms on repeat offenders. Now, this was opposed by the Socialist Party on the grounds that it was racist. They said that because Indigenous Australians were more likely to commit crimes and more likely to be sent to prison already, that such a mandatory minimum regime would be disproportionately applicable to Indigenous people, and that was an outcome they sought to avoid. And so by rejecting mandatory minimums, they painted themselves into a corner and they looked like they were being soft on crime. So they came up with an alternative that they called standard non-parole periods. And so it's basically a mandatory minimum that is not mandatory. It preserved the judicial discretion to reduce a sentence. Today, the standard non-parole periods are listed in Section 54 capital D of the Crime Sentencing Procedure Act, and they range from 25 years for murder down to 3 years for reckless wounding. And the key part to remember about the standard non-parole periods is the term standard. They're not mandatory minimum sentences. They're just a guideline. They're saying to court that for a matter in the mid-range of seriousness, this is what the Parliament is expecting them to do. However, every judge retains their judicial discretion to make a finding of special circumstances and to reduce the sentence below the standard non-parole period, and they almost always do. And this brings us to the case of Muldrock and the Queen. Now, Muldrock was a 25-year-old man who was convicted of sexual assault upon a 9-year-old boy. And he spent 3 months on remand and was then sentenced to 9 years in prison, which is certainly a very heavy sentence. However, the judge in the district court who sentenced him set a non-parole period of only 96 days, which he'd already served. And that meant that he was immediately available for parole, eligible for parole. And needless to say, this gave the tabloids and the radio hosts a great deal to talk about. And if that's all you knew about the case, you would think that that's a very lenient sentence and you might be upset. What the media weren't telling the general public was that there was much more to this story. And that was that Mr. Muldrock was in fact cognitively impaired, such that he had the mind, although he had the body of a full-grown man, he had the mind of an 8-year-old. And furthermore, he'd also been the victim of child sexual abuse. And it was unclear whether he understood that what he was doing was wrong, criminally wrong, as opposed to simply being naughty. The judge accepted that Mr. Muldrock would be a vulnerable person and he would be victimized in an adult prison. On the other hand, a bed was available at a facility that catered to cognitively impaired adults who were displaying inappropriate sexual conduct. So rather than sending Mr. Muldrock back into the community, he was being paroled to live at that facility, which was probably the best outcome for everyone. It was best for him and it was best for the community. He would be there having his needs met, and the public would be protected at the same time. Now, I think you'd have to go a long way before you found anyone who thought that that was not an appropriate sentence to pass in the special circumstances of the case. But the Director of Public Prosecutions here in New South Wales obviously disagreed, and he authorised an appeal to the Court of Appeal on the basis that the sentence was manifestly inadequate, and he relied on the earlier decision in Way's case regarding standard non-parole periods. So Muldrock went all the way to the High Court, and the High Court basically overturned Way's case. They said Way's case was wrong, and in doing so, they endorsed the reasoning in another case called Makarian. So the High Court said that the desirability of Muldrock undergoing rehabilitative treatment was a special circumstance, and there was nothing to stop a judge from making a finding of special circumstances and disregarding the standard non-parole period. Now, you might think to yourself, well, that's all pretty obvious. We established at the beginning that standard non-parole periods are standard and they're not minimum. And judges do retain judicial discretion, and he always had the power to do that. The only question was whether it was appropriate in this particular case. And ultimately, the High Court said that it was.